This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Good day, everyone, and welcome to Financial Podcast. My name is Darlene, and we have a great show lined up for today. These are tough economic times for many. 58,000 businesses permanently shut their doors in Canada, and the Canadian Federation of Independent Business is projecting that more than 200,000 will close by the time the COVID-19 situation is settled. There is a good chance that some of you will have clients that own businesses that have either shut their doors or are contemplating doing so. Today, we have Michael Loberg with us to talk about what happens to some of those businesses as they may declare bankruptcy. Michael is the founder and owner of Loberg Law and has been practicing law in Alberta for over 20 years. He has a great deal of international and domestic experience in the area of insolvencies. Welcome to the program, Michael, and thank you for joining us today. Can you tell us a little bit more about yourself and your experience when it comes to bankruptcies?
Certainly. Thank you very much for having me on today. Loberg Law has been in existence for about 8 years in Canada. I'm the principal of it. As you say, we've been practicing for over 20 years. We have experience in Alberta, the Cayman Islands. We're licensed and have practiced in Cayman and England and Wales as well. Our international insolvency experience primarily stems from the Cayman Islands, but we've also got a vast amount of insolvency experience here in Canada. And unfortunately, there's been a certain uptick of that in the Alberta markets, both with the COVID pandemic as well as results of the energy price failure.
Yeah, there are multiple issues going on in Alberta for sure. So like we said, 2020 has been a tough year on businesses, and we've all seen the headlines about businesses closing. Some will declare bankruptcy, and some will be looking for protection from bankruptcy. I, for one, read these reports with just a general idea of what bankruptcy means, but not a really clear picture of it. So since your specialty is bankruptcy, can you tell us what that means exactly?
Absolutely. As a starting point, there's a difference between insolvency and bankruptcy that it's important for people to know about. Insolvency is the state where you don't have enough money to pay your bills. That's called cash flow insolvency. Or your assets are not worth the liabilities that you have. That's a balance sheet insolvency. Bankruptcy is a legal process which can help you deal with the fact of being insolvent. It's not the only one. There are others. And it's important to know that the difference. Generally speaking, though, insolvency follows a principal rule in business, same as with individuals. When you run out of money, including credit, you're done. There's the phrase in the industry is cash is king, and when you're out of cash, you're done. And that's what leads to insolvency when you can't pay your bills and your assets are not worth your liabilities. When you're looking at that, past that, if the individual or the business is on the verge of insolvency, very often they will be looking at either voluntarily terminating their operations or involuntarily terminating their operations if their creditors are forcing them to do so. The differences that we should know about in bankruptcy is that its primary purpose is to rehabilitate a debtor when they're suffering from insurmountable and unmanageable debt. Now, depending on the nature of the business, an incorporated business versus a sole proprietorship, the goals can be different. And it's important for us to keep an eye on that, because structuring at the front end can allow you to have a very different result at the back end when you're approaching insolvency.
Sorry to interrupt you. So it's important to know, like when you do set up a business, to understand what all of the outcomes could potentially be under different scenarios. That's kind of what I'm hearing from you.
That's absolutely true. One of the things that we're looking at now is that After a year of COVID, and in Alberta, it's not just about Alberta, of course, but Alberta has especially had a lot of problems. After a year of COVID generically across North America, we're seeing an awful lot of businesses that are shutting down, and it's probably too late for them to do any restructuring. However, it's important to note that if you are still solvent, you're still actually able to pay your bills and your cash flow covers that, and your balance sheet has some positive net worth, it's possible to make sure that you've got your structuring in place. And if you don't mind, I'd like to touch a little bit on that issue, because business structuring is really quite important, because it really changes the outcome in bankruptcies or in insolvencies for businesses. The main classes of structures that you've got, your listeners probably know this already, are sole proprietors, where it is just the individual owns the business and there's no legal difference between the owner of the business and the business operation. So all of the debts and liabilities of the business fall upon the owner. The other version is partnerships. Those come in two varieties, either regular partnerships or limited partnerships. Arguably, those can be worse, because in a general partnership, all of the liabilities created by any of the partners fall upon all of the partners. So if one partner makes a mistake, it can catastrophically impact each of the partners.
I was just going to say, yikes.
Yeah, it is very dangerous, actually. And that's one of the reasons why obtaining legal counsel on the front end of setting up a business, even if it's just for a preliminary consultation as to, what is a good idea and what are the dangers, is really important. There are types of partnerships called limited liability partnerships, which mitigate those risks somewhat by limiting the exposure of the partners, to the assets that they put in the partnership. That gets into a bit of a specialty area, because there's a much easier solution, and that's simply incorporation. We recommend at our firm, that everybody be incorporated with one or two corporations in a structure which provide really good isolation of risks. The difference being that risks that are inside a corporation, unless they're personally guaranteed by the owners, that certainly happens a lot, but unless they're personally guaranteed by the owners, are largely isolated in the corporation. So that allows a corporation to be in business, take risks, undertake the usual business activities that create the risk of insolvency in a capitalist system. And as I'm sure you know, 4/5 of businesses, small business startups, tend not to work. So there's no shame in having a business that you try that doesn't work. But if you're going to try it, something that has a bit of a business risk to it, it's good to encapsulate that risk inside of a corporation so that it doesn't spill out and affect the owner in the event that it doesn't work.
Right. That's good advice. And hopefully a lot of people heed it. So for our listeners that have clients that own small businesses and that's their sole family income, what can these business owners do to avoid bankruptcy?
Well, it's important to remember, and let's touch back on the structuring in the first place, and then I'll give you an answer to that question. Avoiding bankruptcy can be possible if there's going to be a workout, if there's a solution that can be had. Now, if the insolvent business activity is encapsulated in a corporation, it may very well be in the owner's best interest just to walk away from it, because there would be no spillover to the individual. If it didn't work, you stop, spend $300 and incorporate a new company and start over again. That very often is your easiest solution. If you're a sole proprietor, however, we get into circumstances where the risks haven't gone away, the creditors are at your door, and you need a solution for that. Now or alternatively, if you do have an incorporated business, but you've given a large guarantee, which is not always desirable, but it sometimes happens. If the creditors are at your door asking for your money, then you may want to go through a restructuring process. Bankruptcy is one of them. The individual can declare bankruptcy. I'll tell you a little bit about what that looks like first. They go to a trustee, they declare bankruptcy. All of their assets vest in a trustee, which means become the property of the trustee. The trustee turns those assets into cash and distributes it to the creditors, and that's all the creditors get. It's important for people to know that as soon as you declare bankruptcy, all enforcement procedures against you stop. So if you're being sued or there's a seizure trying to take effect, that just stops upon declaring bankruptcy. So that's the good news about that. There are some exceptions to that. If you have given a bank a security interest in your property, they can seize the assets that you've given security in. For example, a car which has a secured car loan on it, that's a prime example where the vehicle would be taken. That's not stopped by bankruptcy. There are certain directors and liabilities for wages, taxes, GST, withholding remittances, that sort of thing, which survive a bankruptcy or are dealt with in a priority in a bankruptcy. So there are different types of debts. That's the takeaway for that. But as far as The choice goes when the individual reaches the point of insolvency and the debts are unmanageable. If they are engaged in a business, there's an important process that I want to tell you about, which is called a proposal, which is under the Bankruptcy and Insolvency Act. It allows for the rehabilitation of a business debtor or an individual debtor, but we're talking about businesses here. It allows for the rehabilitation of a business so that potentially the business can survive. And what happens is you get a trustee in bankruptcy, usually in conjunction with a lawyer who's experienced in these kinds of things, and put together a proposal to your creditors to say, I can't pay you everything, but if you let me continue to operate, I will be able to give you more than you would get in a bankruptcy. And here's what I propose to you. And there are certain statutory requirements, such as you must pay your staff, you must pay your withholding remittances, you must pay your taxes. But other than that, you can get as creative as you want in writing the proposal to your creditors. And I can guarantee you this, any commercial creditor who receives a proposal where they think, yes, this actually does give a reasonable prospect of getting more than I'm going to get in a bankruptcy, is going to look at that very seriously and very favorably. So if you want to not become bankrupt and you want to have your business survive in operations, a proposal is a very important process to consider because it does let you make a deal with your creditors.
Okay. That's a great option for a lot of people that are probably not aware of it. I knew of it on an individual personal side, but I didn't realize businesses could actually go that route as well. So that's a good option. Now, my next question is very similar, and I think you've probably answered it, but it's sometimes bankruptcy is the best option. So what can these business owners do to best prepare for that? And is the process different if the business is a small or a large corporation? You kind of answered it, but not if there's a difference between a small or a large corporation.
Well, there are some alternative options. Without getting into the technicalities of it, there is a larger version of the proposal. That is, the proposals are done under a Bankruptcy and Insolvency Act mechanism. There's a larger mechanism under the Companies Creditors Arrangement Act. It's commonly called CCAA proceedings. That's where you've got a very large corporation with more than $5 million in debt. And this particular law was created for specifically restructuring large corporations, primarily because they have a large impact on the economy of the area. You don't want your major employers failing, for example. So that is a significant difference between the larger and the smaller businesses. But in the end, the process is largely the same. Retain counsel, get a trustee in bankruptcy or a proposal trustee or a CCAA trustee monitor to come and assist you in putting together a plan that will allow your business to survive. As far as what can a business owner do to prepare for an insolvency? Well, there's a bit of a conflict, but I do want to give you this information. The directors of the corporations that are approaching insolvency do have a fiduciary duty to look at all creditors equally and be fair. But there's an inherent conflict where the directors also have given personal guarantees. They've got directors' liabilities for withholding taxes and GST. So to a very large degree, it's important, and this part isn't improper in any stretch, is to pay the taxes, pay the GST, pay the obligations of the corporation that have personal attachments, liabilities that flow through to the directors. After that, there's always a pressure on the guarantors of any corporate debt to want to see those debts paid first. Other creditors may find that objectionable, but we see this all the time where the owners of the corporation will pay off the obligations where there's personal guarantees. Again, those may be challenged by other creditors, but that's a fairly common maneuver that happens. After that, consult with a trustee and consult with a bankruptcy lawyer. It is important that you get some advice. And one of the reasons why it's important to get some advice from a lawyer is because the lawyer will be acting for you and giving you advice on your circumstances. And if insolvency is unavoidable, a whole bunch of things become things that you don't need to concern yourself about. For example, if you have creditors at the door, you've got statements of claim showing up, you may consider, do I need to spend money on defending this? If a bankruptcy is inevitable, no, you don't need to do anything. If it's an incorporated business and is not going to survive, then no, you don't need to do anything. Don't spend your money on that. You can save that. If it is desired that you want to do a proposal, then there's a one-page piece of paper called a notice of intention to make a proposal that could be filed that will buy you time to stop everything so that you can consider your financial circumstances. So those are the sorts of things that a owner of a small business should be considering as the business is approaching insolvency.
That being prepared for that would probably put their minds at ease a whole lot more. Just understanding that it's not, it doesn't have to be as scary as what it seems, that with the right counsel, you can get through it fairly steady, fairly all right. You're not going to go off into oblivion. You'll survive it. So
I think that's a very important observation. I can't name names, but I can tell you of one client that I'm working with right now that owns a $10 million industrial complex. And they came to me with some questions about, how can we fix this? This isn't working. And regrettably, the answer was, this is not going to work, right? Let's distribute the assets in an orderly manner, cooperatively with our creditors. We'll ensure that nobody does anything offside so as to give any reason to, have any claims that come afterwards. The guarantees were negotiated to be extinguished. Government obligations were paid. The people who tried the business that failed, and it failed purely as a result of COVID, not as a result of anything they did. They walked away from it. And before they phoned me, they were having ulcers and very, very nervous. And afterwards, it's like, okay, this is just what's going to happen. And it was okay. I mean, it wasn't great, but it was okay.
Yeah, that's right. It's never going to be great, but still, you can survive it. So with respect to insurance, when it comes to these businesses, and I'm not sure if you can answer this question, but if a business declares bankruptcy, I would assume that all insurance is canceled at that point in time. But if the owner wants to start up a new business, do you know what some of the roadblocks would be to get insured again, or even opening up a new business?
Well, if the business is incorporated, then the insurance policy is a corporate asset. If you're walking away from the business because, and it's important to remember that walking away from an incorporated business that fails and not putting it through a bankruptcy process is usually a very reasonable thing. If you look at business bankruptcy statistics, you see very few incorporated businesses declaring bankruptcy because simply you don't rehabilitate corporations that have become insolvent. So if there's an insurance policy that's in there, to the extent that it's an asset, the creditors may choose to realize on it. If it's a sole proprietor who has an insurance policy of some variety, there's no particular reason why that policy should go away as long as the premiums are being paid. And as far as the ability to get new insurance for opening up a new business, there should be no impediment to that by a bankruptcy or an insolvency. Getting new credit is very often somewhat challenging, but I wish to stress it's not impossible. Immediately after being discharged, you'll get a small credit facility with a bank. You'll get a Visa card, and you can start rehabilitating your credit. If you're working with a bank properly, especially if you work with the bank during the insolvency process, they'll usually work with you afterwards. So this is by no means a showstopper for future business endeavors.
Okay, that's going to be reassuring to a lot of people. And that actually is a great segue into the next question. We talk about, we know eventually a bankruptcy is going to be removed from a business's credit rating and it'll be discharged. So what does that mean? And what are generally the steps a business owner would have to take in order to make that happen?
Well, again, if it's an incorporated business, you don't worry about it because it affects the corporation and not you personally. So we'll just set that one aside. As a matter of personal bankruptcies, it's going to stay on there for several years and then it's going to come off as pretty much automatically. So there's nothing really that you need to do. I always recommend monitoring credit reports throughout the process. Sometimes weird things get on there, claims that shouldn't be there as a result of steps that people are taking that they're not allowed to take because of a bankruptcy. Again, a bankruptcy stops all proceedings against you. If you've got a bank facility and you stop paying, it is going to go to an R9 credit rating fairly quickly, and that's the natural consequence of that. Then the bankruptcy will be recorded on that, and then several years later, that will all go away. I recommend monitoring your credit report just in case something unusual appears there. You can take care of it. There's also a facility for putting a statement on your credit report if you wish to make an explanation to future creditors. Although practically speaking, you don't need to do that unless there's something weird going on. But practically speaking, after you're discharged from bankruptcy, get a relationship going with your banker again and, try again. It's going to be a little bit challenging the second time around, but as far as the credit rating goes, there's not really much that you have to do about it other than monitor it, which I recommend for everybody, periodically checking your credit rating, regardless of whether or not you're in the zone of insolvency.
That's right. I mean, identity theft happens frequently, so it doesn't hurt. So just so I'm clear on this, though, when an incorporated business declares bankruptcy, how long is it before they are discharged, or is it they just dissolve the incorporation, they can start up a new one, and that's it? It's a little bit of an abbreviated process, but is that generally what that means?
Well, I think it's really important for your listeners to know the vast difference, the critically vast difference between an incorporated business and the individual who owns it. An incorporated business can go on and undertake risks, perhaps larger risks than the individual would be willing to take in the business sector, of course. And if it doesn't work and the company becomes insolvent, it can't pay its bills, it usually simply just stops operating. And you then cooperate, as we talked about before, with making sure that the withholding taxes get paid and all that. Then after that, the creditors just take what they can get out of the corporation. And the owner doesn't really have to worry about being involved in that process, right? They need to not impede it, right? That would be improper. But other than that, creditors, it's a free-for-all. Go get your stuff, right? Typically, you don't pay a trustee to run an insolvency process for a corporation because the corporation won't survive the Insolvency Act. You're not trying to rehabilitate it. Unlike an individual where, they're going to live past being insolvent, so they need some process to extinguish their debts and let them move on in life.
Okay, that's a good distinction, and thank you for clarifying that for me. We've talked a lot, you have a lot of experience with insolvencies, and there's a reason for that. So what is the advantage of having legal representation when it comes to a bankruptcy or insolvencies?
Having a lawyer involved in the process, especially a lawyer who's familiar with the insolvency process, is really quite important. And that's going to sound a little self-serving, but it really is quite important because, there are a variety of processes that can be undertaken. Again, the personal bankruptcy, technically speaking, there could be a corporate bankruptcy. If you're a creditor, that's typically where your corporate bankruptcies actually happen. If you want to try to rehabilitate the business, you can do the proposal pair that I call them under the Bankruptcy and Insolvency Act, which is first an informal proposal to all of your creditors. If you've got a lot of creditors, they may not be able to make it happen. If you've got a manageable number of creditors, you can try. If an informal proposal doesn't work, you can go to a formal proposal under the Bankruptcy and Insolvency Act. The nice part about that is if you can get 50% plus one in number of your creditors representing 2/3 in value of your debt, you can force the other creditors to take the deal involuntarily. And that can rehabilitate your business. Now, those are not expensive sorts of things that, for a lawyer to tell you about, but you're typically going to need a lawyer to tell you about them. If you're a larger corporation and you're looking at $5 million worth of debt with a CCAA process, you're absolutely going to require counsel to assist you on that.
Yeah, I mean, it could potentially be a complex process and you want to make sure that you're protected. So I think you've given us a lot of great advice here.
Thank you. It can be somewhat complicated and there are steps that are taken, but typically my encounters with creditors, just to give a preliminary overview of, what are your options and what's going to happen here and what are the things that you need to be worried about, take about 30 minutes to about an hour, right? And we've touched on a lot of them here already. It's important that in the run-up to an insolvency event of any sort that, people are aware of their director's liabilities, their guarantees, and, what they're obligated to do in order to make sure that everything is done in a legal and proper manner. But that doesn't have to be a big consultation. I know I said this already, but I do want to harken back. That's the advantage of having legal representation in a bankruptcy. I urge in the strongest possible terms, all small businesses, when they're first starting up and they're starting to turn from anything beyond, a home-based hobby kind of business into a real going concern, take the time to call a lawyer. Or if you don't have the funding for that, read a few materials that are available in a lot of different sources, including the podcast that we're talking on now, as to how you should structure, what your liabilities are. To be perfectly clear, incorporating a company can be done for a few $100s, and that can isolate all kinds of liabilities, away from the owner. There's also I won't get into it now, but the holding co-operating co-pair, which can not only secure the owner from the liability resulting in the company, but it also lets you be your own bank. In effect, you can be the secured creditor of your own operating company. So to the extent that you have to put some money in there, it's safe. You can get it back out if you need to.
Excellent. Good options. So 2020 was a little bit of a different year, I think, in a lot of different ways. For some of those small businesses that have been forced to close by government policy, have you noticed any flexibility with the creditors of that business? Like, have things changed since, 2019 during 2020 in that area?
2020 has been an apocalyptic year of its own nature that's entirely unlike anything I've seen in the history of being in this business.
Like with everything else.
Yeah, it is just simply a remarkable state of affairs for individuals and for business, especially for business. We've seen such a massive number of business failures and such a massive change in the business environment that it's really hard to compare it to other years. As to creditors, I have noticed that quite a bit of a difference in how they're reacting, although there's a common theme with them. Creditors always act in their own self-interests. 2020 is no different. What they're looking at is typically banks are saying, well, I could realize on these assets and sell them. But if it's a restaurant, say, nobody's going to buy the equipment that they could seize and sell. If you're a landowner and you've got, for example, a restaurant in your building and they are now closed and they're not paying any rent, you could notionally throw them out and seize their assets, or both if it's done properly. But again, nobody's going to buy the assets, and you can't release the space in any event because there are no businesses operating. So the environment has changed significantly for the creditors, which has forced them to engage in a significantly different realization process. Instead of saying, I'm just going to mop up the assets, put them up for sale, and I'll get what I'll get, and then I'll release the space out and carry on, or go and do the next deal for the finance companies. There are no next deals, right? And there is no place to sell these assets very often. So they're simply forced, as a matter of self-interest, just to wait, which is a little different. I mean, we've seen that from time to time in prior economic collapses where the banks didn't want to spend the money on the lawyers in order to go and realize on the corporate assets, where they'd rather just wait. We're seeing quite a bit of that now.
Oh, yeah, in the hopes that there'll be a turnaround within the next year or 2 years or whatever the case may be, I guess.
That plus the fact that, again, with the economy flatlining, a lot of businesses simply being closed, seizing the assets and trying to sell them will literally cost you more than it's going to realize in proceeds.
Yeah, I can see that. Well, this has been such an informational conversation, Michael. I really appreciate it. Thank you so much for explaining all of that to us.
The pleasure's mine.
It's really not a situation that anyone wants to believe will happen, and nobody opens a business with the expectation of filing for bankruptcy. So as a final thought, if you have any final thoughts, please share them with us and let us know how our listeners can get in touch with you.
Sure. I think that the biggest takeaway that an entrepreneur should take, or anybody advising entrepreneurs, is to do your structuring early. Do it before you start up, and certainly do it before you've got creditors on your horizon that you're incapable of paying. Takeaway number 2 is, and this is quite new, although it's always been the case that 4/5 of small business startups don't work. So there's no shame in trying a business enterprise that doesn't work. You hear very often of a lot of people who serial entrepreneurs. They try something, it fails. They try something, it fails, and then they try something and they become billionaires. Right? That's a fairly common theme. The capitalist system that we work under doesn't work unless people take risk, and risk invariably leads to failures, and there's no shame in that. I would specifically add that, especially during the pandemic, nobody's responsible for what we're going through. And the businesses that fail in this environment, there's no shame in any of that either. So I wouldn't be carrying anything away from that. That said, entrepreneurs do tend to dust themselves off and start over again. Please make sure that the listeners know that when they're setting up again, they want to go try it again, that they've got their asset protection structures in place, be it corporate structures, trusts, that they've got a clear view on how they're going to manage the risks that they're going to undertake. So if the next one doesn't work also, or the pandemic isn't over, say, they've got a plan for that and how to work through it. Now, if anybody wants to talk to my firm about that, that would be absolutely a delight. We're based in Calgary, and my phone number is 403-668-6561, or you can reach out us at 1000 Bankers Hall, 888 3rd Street, Southwest Calgary, T2P 5C5.
And we will have all of that contact information on the website when this podcast goes live. So thank you again, Michael. This podcast, just so everybody knows, is sponsored by Customplan Financial Advisors. And if you would like to appear on the program, or someone who you think would be a great guest, please send an email to contact@financialpodcast.ca. And Michael, thank you again, and I hope you have a great day.
Well, thank you very much for having me. It's a pleasure to be here.
Take care. Bye-bye.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.